Good morning, everyone. This is Manny Gonzalez, Director of CATS. Thank you all for joining us. I just wanted to give a quick heads up that we'll be starting in about a minute or two, just to give folks some time to check in and to get settled. I will be providing some remarks and some introductory information in terms of logistics shortly. So for the time being, please feel free to just settle in and I will give folks one more minute. All right. So again, thank you all for joining us. This is Manny Gonzalez over here at the Community College Association of Texas Trustees. Thank you all for joining us on this first of a series of webinars that we'll be doing this fall in conjunction with the Texas Success Center. As you all know, our in-person meeting has been canceled by virtue of issues related to COVID-19. But we still want to remain dedicated to providing some professional development and leadership engagement content. And so this will be the first in a series of webinars that we are providing in hopes that you all can still stay engaged and receive some information that can be helpful in your responsibilities and roles as trustees and regents across the state. We felt that this topic was really timely by virtue of the fact that many of us are now adjusting to the new normal of virtual business. And so I am pleased to welcome Amy Magee from Texas Association of School Boards as she does a presentation open for virtual business, considerations for virtual board meetings and business. But before we get started, I do want to remind folks that this is being recorded. And so for whatever reasons you have internet issues, or if you have colleagues who are unable to join, or if you need to leave a little before the hour, this will be shared through the Liaison Network. And please feel free and encourage your colleagues to view if they have any questions on any of these items. Additionally, Amy Magee has provided some resources that I will be sending out that can be helpful in navigating some of these considerations in your virtual settings. I do want to add also that that all 50 community colleges boards are members of the Texas Association of School Boards. And so the services that Amy Magee provides as the director of the community college, as director of community college services at TASB, are available to you all in some capacity. And so Amy will probably provide some clarification on what that means in terms of what types of services that she can offer, but they are a resource that you and your colleagues can leverage when dealing with board matters. Now, I also want to add that for logistics reasons, in terms of our webinar size, we will be only providing the opportunity to provide Q&A via the chat function. And so if you are joining via phone call, you can try to text me at 713-817-8935, but for those who are joining via chat, that's where we will be facilitating the Q&A, and I will be providing those questions to Amy as they come up. And so please feel free to share them in the middle of the presentation, but we will also reserve some time at the end for Q&A as well. And now, before we get started, I do want to read our presenter's bio. And so I will quickly, if you'll humor me, provide Amy's background. So Amy became the TASB Director of Community College Services in 2018 after serving as an attorney in TASB's legal services for 16 years, most recently as Community College Counsel. As Director, Amy oversees the activities of the department as well as provides support to TASB's community college members and TASB's other service areas that assist the college. Amy provides legal advice to the community colleges and develops and reviews their legal and local policies. She's a frequent presenter at local, regional, and statewide training events on a number of legal topics affecting the colleges, including governance, business, employee, student, and community issues. Prior to exclusively serving the colleges, Amy also worked with TASB's school director members, providing legal advice and education and policy development services. Amy received her Bachelor's of Science in Psychology with University and Foundation Honors from Texas A&M University and her JD from the University of Texas School of Law. She is a member of the Texas Association of Community Colleges Attorneys, the State Bar of Texas School Law Section, the Texas Council of School Attorneys, and the National Council of School Attorneys. And so with that, thank you, Amy, for joining us, for always helping us out in terms of our community college questions, both related to boards, to CEOs, and we look forward to hearing your presentation. So without further ado, Amy, the floor is yours.
Great. Thanks so much, Manny. I am so happy that you all were able to join me today so that we can discuss technology issues. I am certain that you have used technology in your role as a trustee prior, but the coronavirus pandemic definitely has required that we use technology more than ever before. And while that technology can bring a number of benefits to your work as board members, it is not without its complications. So today we're going to go ahead and discuss how to effectively use technology to help you stay within those legal parameters. Now, just to give you kind of an overview of the subject matter we'll be discussing, of course, we'll talk about the fundamental issues related to conducting remote meetings, but then we'll move into issues related to, for example, the college issuing you technology resources or you using your own cell phone to discuss college business. Then to issues related to electronic communications and records. How do electronic communications implicate the OMA? What about records retention concerns and the Public Information Act? We'll discuss social networking and provide some tips about how to appropriately handle social media, but then also considering mobile device security to the extent that you are using your cell phone or other mobile devices to conduct college business. We'll discuss cyber harassment in the unfortunate event that someone from the community might be harassing you online, some tips about how to handle that. And then finally, discussing response to board members' online conduct. So if there is a concern about a fellow board member and their behavior online, how can you handle that as a board? But additionally, we will have a bonus discussion with all that is going on with coronavirus right now. I certainly don't want to miss out on answering some questions that we are frequently getting about liability and employee issues. So at the tail end of our technology conversation, we'll pivot to some coronavirus FAQs for just a bit. Okay. Let me initially mention the documentation. As Manny said, he's going to send you a document that is basically an index of various links that we have to documents on our college e-law. So you may choose to visit college e-law right now. As you see, it is available on our website, which is colleges.tasb.org. If you look to the left, there is a menu that allows you to select resources, and then you can select college e-law. In particular, on that page in relation to today's discussion, under the governance heading, we have a trustees and technology handout, that will be the bulk of what we're discussing today, but we also do have a remote participation in board meeting FAQ under that heading, as well as social media guidelines for board members under that heading. And of course, as you may have noticed in that prior slide, we have a number of coronavirus resources that are available on employee issues, questions about students, closures of your facilities, etc. Okay. So let's move on to our very first topic, and that is how to conduct remote meetings. Now, there are two special provisions that allow you to conduct remote meetings, two categories really, I should say. One is a teleconference meeting. You could choose to meet by teleconference. There are two provisions that allow you to meet by teleconference. One is in the event that you have a special meeting and immediate action is required, and it is just really difficult for you or impossible to convene a quorum in one location. In those instances, you can have a teleconference. So that's not really tied to you having a quorum in one location. It doesn't matter if quorum is in one location or not. If you fit these special criteria, then you can have a teleconference meeting. And basically then you just need to provide notice that the meeting is going to be held in the same way that you would provide notice of any other open meeting. You just would mention the regular location of your board meetings as the location of this meeting. There are certain requirements that you make sure that this meeting is audible to the public at that particular location, and it has to be broadcast online. And then you must record it and put it online in an archive. Now, the second type of teleconference does require that a quorum be in one location. So that's what you would be more likely to use for a regular meeting in the event that your quorum can meet at your regular meeting location, but you may have a couple of members who can't attend in person. And so then you can choose to have a teleconference. Again, same notice requirements as the OMA, but there are specific requirements that you have audible two-way communication the entire time. Make sure to have a recording available to the public. But this is kind of an interesting tidbit for this particular type of teleconference. And in that event, members who participate remotely are counted absent. So as you may recall, there is a law that requires that you attend at least half of the meetings, the regularly scheduled meetings per year, or you could be subject to removal by a court unless, like, the board has given you, the board can grant you an excuse, but you would be remotely counted absent if you're participating in the teleconference under this provision. Okay, so those are the two teleconference provisions, but there's also a video conference provision. And this allows you, again, it's tied to the quorum being in one location, unless you are, unless your college covers 3 counties. In that event, then the presiding officer only needs to be in that one location. It does have very specific two-way communication requirements. DIR has put out very specific requirements. It's important that everyone, the public, the other members can hear and see each other at each location. There's specific requirements to stop the video meeting if the signal's lost. It overall, it follows the same notice requirements with an additional intent that the quorum be present on the notice. And there has to be an audio recording of that meeting. Now, that is the law as it exists normally, but of course you may be familiar with the fact that the governor has waived some of the quorum requirements due to the coronavirus disaster. So the waiver of these OMA requirements is applicable as long as the disaster declaration is in place. So it may be that your college is coming back on campus, your facilities are opening back up, but the disaster declaration is still in place. Even that will allow you to continue to have your board meetings under these special waiver provisions. Just matters basically when the governor releases the disaster order. But that said, basically these waivers will apply to the quorum requirements. So for the video conference provision, for that second teleconference provision that are reliant upon the quorum being in one location, it waives that requirement that the quorum be in one location. That said, you still have to make sure that you're following all of the appropriate two-way communication, all of that, all of those requirements that allow for everyone to be able to hear each other. That is still in place. Now, you may also be familiar with the new public comment requirement that was put into place this last session that requires you to have public comment before on every item that is on the agenda before or contemporaneously with the discussion. That requirement is not gone under this waiver. It is still there that you have public comment, but it's eased somewhat in that it gives you some alternative methods of communication, like, for example, allowing people to call in, allowing people to send comments early. Basically, you would just need to make sure you have some procedures in place. Now, of course, remote meetings can cause technical issues. I have received a question about voting concerns. And so it may be that you can't, for example, if you're doing a voice vote, that you can't really hear your other board members and how they are voting. Now, keep in mind that the college can vote by any method, as long as you're not using some sort of secret ballot. And arguably, if you can't really hear how people are voting, it may be a concern that it's not actually a public vote. So you do want to make sure that people can hear and do know what the vote is that your board members are taking. So you can do that by roll call, you could do that by a show of hands, whatever may be the appropriate way to communicate to the board and to the public how an individual is voting. And then you, and I think it's also important to keep in mind that, for example, if you're doing a video conference, this could violate the video conference rules if you can't really hear your other board members either, because they're very, very specific under those video conference rules about making sure that everything is audible. So I see that there's a question about suggesting roll call as primary. It really depends upon what is appropriate for your college and how you're handling your meetings. So yes, certainly if you think that having a roll call is the best way to ensure that you're hearing everybody's vote and that the public is able to be aware of everyone's vote, then that's appropriate. But you may find that your technology is fine and that one of the other methods works just fine. So bottom line, just make sure you're doing you're choosing a voting method that allows your other board members and the public to know how everyone is voting. Okay. So let's then move on to issues of technology resources. Now, the board may receive technology from the college, whether it may be a issued laptop or a tablet or some other way to allow, for example, participation in board meetings. It may be a method of communication, such as a district issued email, which frankly, it can be nice to have an actual email to conduct your business as a board member, as we'll discuss a little bit later with concerns about some records retention requirements and the like. It can be beneficial to have a specific college email address. But all that said, there's a lot of different types of technology that the board may be issued by the college. And if it is the case that the college issues board members technology for use for business purposes, you should make sure the board should adopt a policy to discuss how those technology resources can be used, kind of setting those parameters. For those of you who subscribe to TASB policy services, that policy is BBI. And you'll see under that policy that it has provisions related to acceptable use, basically requiring that board members sign an acceptable use agreement that addresses issues like security of the technology, password protection, what the appropriate conduct is, concerns about copyright and other intellectual property use, concerns about sharing confidential information. This should all be addressed by the acceptable use agreement that is issued to the board members. And again, this is discussed in policy BBI. Something else that you'll see in BBI is a concern related to personal use. So to what extent can the board members use technology issued by the college for personal use, not simply business use, but personal use, like sending an email to a family member or something. Now, personal use of college technology by board members does implicate two major concerns. One would be the gift of public funds concern. There is a provision in the state constitution that prohibits governmental entities from essentially gifting public funds by giving some sort of benefit to a private individual for private purposes. And so, the use of personal use of a device could be considered a gift of public funds. But we have looked to some legal authorities that have said that as long as that personal use is reasonable and incidental, and if there's no direct cost and you're not impeding governmental functions, then that will not implicate the gift of public funds. Now, the second major concern is going to be income tax provisions. It is technically personal use of college technology is a taxable fringe benefit, which is unfortunate, of course, because you are not you're not paid for your work as a board member. Doesn't matter to the IRS. It is considered a taxable fringe benefit to engage in personal use, with the exception of de minimis fringe use. So if that use is just so small that the accounting is unreasonable, then it's not going to be something that's going to implicate income tax return concerns. So both of these are addressed in BBI and should be addressed in your college's local policy. There, of course, are concerns about monitoring this technology and questions about whether, since it is college issued technology, can the college monitor your use? And this is actually something that the college needs to do under the Digital Millennium Copyright Act. So basically that's just trying to make sure that people are not inappropriately using others' copyrights. As that technology provider, the college could be held responsible for any violations. And so under the Digital Millennium Copyright Act, college does need to be able to monitor your use of college technology. And also just generally, the college, you're gonna have an interest in making sure that your fellow board members are properly using that technology that has been issued by the college. So with that in mind, you'll see language in BBI that says that the use of the technology is not private and will be monitored. There are legal provisions that address concerns related to theft, loss, or damage of that technology. So certainly the college can choose to have a board policy that addresses any payment or attempts to recover college issued technology, but there's also specific provisions under law that could lead you to liability if it's an intentional or negligent damage or destruction, or if you fail to exercise reasonable care and that college technology is stolen or is deteriorates. So very important concerns when dealing with college technology, but I think there are some benefits to having technology issued by the college. So certainly weighing all of those concerns and making sure that you have a policy in place to address these concerns. Now, what if you're using your personal cell phone to conduct college business? So for example, what if your college president is calling you to discuss an issue? Now, you can be reimbursed for any expenses that you incur while doing your duties as a board member. And so that's also going to apply to your cell phone use for college business, but it has to be addressed in board policy. So under the TASB scheme, that's policy BBG. But keep in mind that using your personal device for college business can be risky. We're going to discuss a little bit later some issues related to mobile device security and confidentiality. All right. Let's then move into some concerns related to electronic communications. And we'll discuss electronic communications not only between fellow board members, but also board members and the administration. Now, of course, communications between board members naturally implicate the Open Meetings Act. If you look and kind of drill down into the definition of what is a meeting, what is a deliberation, basically communications that involve a quorum of the board, and whether it's a verbal or a written exchange, will constitute a meeting under the Open Meetings Act. And as we know, a meeting must be publicly posted. So with that in mind, it doesn't matter if you didn't intend to have a meeting can be potentially implicated if you are communicating and writing outside of a properly posted meeting. So with that in mind, and two, this can be by email, if you're communicating by email, by text, by social media. So think about it in these various contexts. And it doesn't matter whether an individual actually replies. If you have engaged in communications with a quorum of the board that builds into a quorum of the board, sharing your actual thoughts, that can be considered a meeting. So if your quorum counts as 4, if a board member sends an email out to 3 fellow board members to mention that board member's thoughts on an upcoming issue, that is a meeting, even if those other board members don't respond. Now, it could also become a walking quorum, and that is a situation where board member A writes board member B an email to discuss a matter of college business. That isn't involving a quorum, so that doesn't implicate the OMA. But if board member B passes on board member A's thoughts to board member C then passes along board member A and B's thoughts to board member D, you now have a communication thread between 4 board members, even if it wasn't originally intended to be that. So that is considered a walking quorum, and could potentially result in an OMA violation if you're having this discussion outside of a posted meeting. And they do have a number of criminal and civil penalties. So for example, a person could bring a lawsuit to stop an action that the board has taken that seems to be that seems to have occurred outside of a properly posted meeting. You as the board member also could be criminally liable. You could be subject to a misdemeanor fine or imprisonment if you participate in a discussion with a quorum. Now note this criminal penalty, it's 551.143, actually was changed this last session because there was a Supreme Court opinion, Doyle v. State, last spring that said that the criminal penalty as written was too vague. So they have cleaned it up some, but it's still there. So if you know at the time that an individual communication is going to be passed amongst board members, then you could be subject to this misdemeanor penalty. Also, if you knowingly call or aid in calling or organizing an unauthorized closed meeting, that is also a penalty. That's also a misdemeanor. So you just really need to be careful about communicating with a quorum of the board outside of the meeting. I do see the question about what if the board liaison emails the board, and can the administration provide the board with updates? Yes, certainly. So of course, it is frustrating when you may be going a long period of time in between meetings and you really just want to be able to have a good sense of what's going on in the college community so that you can do your job appropriately. So yes, certainly the administration, whether it is the college CEO or the board liaison, those individuals are not board members and so are not technically subject to the OMA requirements. So with that in mind, they can certainly send updates to the board. They just need to be cautious that they are not acting as an intermediary. So, basically, there have been individuals in the past that from other governmental entities that are administrators and got in trouble because they were basically helping a board member circumvent the OMA by passing along their thoughts to other board members. So just need to be cautious in what is being sent. So certainly if you receive an update or you're concerned about something going on in the community, you pass along notice to the board liaison or the CEO. The CEO or board liaison can certainly send out updates to let the rest of the board know what's going on, but they just don't want to act as an intermediary and essentially be passing around your thoughts on those matters. That makes sense. So, and yes, and the form could be taken as emails or text message. Now, keep in mind, there is one exception that hasn't been heavily utilized, but is out there. You could set up an online message board if you wanted, that is on the board, on the college website, easy for people to find, that allows for you to deliberate in between the meetings. No action can be taken, no actual votes, nothing of that matter, but simply deliberating. So that is technically an option, but that also means that you're kind of setting up something that becomes a public record and that is out there for everyone to see while you're still kind of sorting out your thoughts. So, so it's something to really consider heavily before you put it into effect. Now, a final few concerns related to electronic communications. Of course, electronic communications trigger potential First Amendment concerns. From the standpoint that if you are subject to the OMA's restrictions on being able to communicate, is that a First Amendment violation? Because is it considered a restriction on your right of free speech? Now, there has been a Texas Supreme Court decision that concluded that the OMA's restriction on your deliberation of public business outside of a posted meeting is content and viewpoint neutral and is justified by the need for you to be transparent, to make sure you're not committing fraud. So for all of these reasons, the OMA restrictions that I just discussed are not considered violations of your First Amendment free speech rights. Another question that comes up often is, can you use electronic communication for a private conversation during a meeting? So while the meeting's going on, could you be texting each other? Or could you be IMing each other to discuss the matters that are either on the agenda or not on the agenda? Now, keep in mind, it could raise some concerns under the OMA that looks like you're taking secret action in violation of the Open Meetings Act and its closed meeting provisions. Of course, you can only go into closed meetings for certain reasons. And so it could look like a secret action in violation of those closed meeting provisions. It's also a concern if you're discussing matters amongst a quorum of the board that aren't posted on the agenda. So you should take caution in how you are communicating using technology while a meeting is going on. And of course, those notes that you're taking may be considered official records that you have to maintain and then disclose subject to the Public Information Act. And this has come up before in other entities where the boards city councils were having discussions by text message and IM and email, and members of the media noticed that this was going on. And so those were public records, and so they had to be released. And so there could be a lot of complications if you're not careful how you're using technology even during the meeting. Okay. So next then, I was alluding to concerns related to the retention and disclosure of information. And so let's discuss electronic records. Now, there are two major concerns that come up with electronic records, and those are those related to records retention and records disclosure. Under the former scheme, prior to this last session, basically records retention concerns were addressed by the Texas Local Government Records Act, and records disclosure concerns were under the Public Information Act. But this last session muddied the waters a bit because the legislature chose to add a PIA provision that addresses the retention of records. And so I'm going to discuss that in just a second. But first, I do want to discuss the Texas Local Government Records Act and what that means to you, for you as a board member in relation to your electronic records. Now, under the Local Government Records Act, the records definition is very, very broad. It could be all kinds of writings, images, recordings that are created or received by the college or by a board member or by employees pursuant to law or in transaction of official business. So this is going to include emails, IM, your social media discussions, your text message discussions. So it can come in all different kinds of forms. We're really focusing on, is this in relation to the transaction of public business, and was it created or received by an officer or employee of the college? Do note, though, that the Act does have a very, very limited exception for some notes, journals, diaries, or other types of documents that you are maintaining for your personal convenience. Very, very limited exception, but it may be that some of the notes that you are taking, if they are truly for your personal convenience, may be something that is not subject to the Local Government Records Act records retention. It's different than the PIA, but for the Local Government Records Act. Now, under that act, you do have to maintain the records in accordance with the state records schedule at a minimum. You as a college may choose to put more onerous requirements on, but you do have to follow the state records retention schedules. There's 4 that apply to the colleges. There's one specific to community colleges, one for local governments, and one for elections, and one for voting information. So, or excuse me, tax information. So, so there are specific records retention requirements, and they are broken down by the content of the record, not the medium of the record. So it doesn't matter if you're sending it by text message or email. If you are engaging in a discussion about policy, that is going to, policy development, that is going to be considered a memo that must be retained for 4 years. So it's based upon the content, with the exception of that message board that I mentioned. If you were to have that in place, there's specific requirements just because something's been put on the message board. But outside of that, we're looking at the content of the record. Because this can be very complicated and there are so many different ways that you may be receiving information, I highly recommend that your college put together a protocol on how to handle information. So, so really, I would recommend that you have either some sort of filing structure, but even better, if it is something that is a record that should be retained by the community college, having a protocol that you forward that information on to the appropriate individual, that will be just fine, because under the Act, you're not required to keep copies of that information. So you can simply forward it on, as long as it has all the metadata and all the information around it, you'd be able to forward it on or store it however the college protocol may be, and then you don't have to maintain that information anymore. But keep in mind, if you do still have records that you have been retaining that are considered local governmental business, that they must be released under the Public Information Act, even if you could have destroyed it under the records retention. So that's why it's really important that you stick closely to this protocol so that you don't have a lot of extra information around. Now, as I mentioned, the Public Information Act does have new provisions where temporary custodians, defined as a current or former board member who creates or receives public information on official business, must either preserve that in accordance with the records retention procedures or forward it to the public information officer. And if you haven't forwarded it, the public information officer may come and ask you for it if they get a public information request, and you have to surrender it within 10 days. Now, as far as disclosure of that public information is also a very, very broad definition: written, produced, collected, assembled, and transaction of official business. And it can take any form, and specifically mentions electronic communication. So unless a special exception applies, like FERPA exception or certain board member contact information or a memo regarding policy development, that information is going to be subject to a PIA disclosure. And there is not an exception for personal notes, as there is under the Records Act. If you do not comply with disclosure, or if you destroy the information, you could be subject to a misdemeanor. But of course, your private matters, that's not subject to PIA. Even if you engaged in a discussion about, say, your child's birthday on college district technology that has been issued to you, or your college district account. What matters is it actually college business? And so for that reason, I definitely recommend trying to keep all of your personal discussion and public life separate. That's why I would say having a separate email for your college business is going to put you in a better place than if you are basically using the same email account for all your college and personal business. Now, let's go ahead then and turn to social networking. Similar sort of analysis on some of these concerns. For example, under the Open Meetings Act, as we discussed, you could inadvertently engage in a meeting in violation of the act. This could happen if, say, you have a number of the board members who are your friends on Facebook, and you post your thoughts on college business and a quorum of the board sees it. That could arguably be considered a meeting because it only requires one-way communication. So really do need to be careful about your use of social media and how it might implicate the OMA, of course, unless you have that online message board. It also is going to implicate the records retention concerns that I mentioned prior. Helpfully, the State Library and Archives Commission has issued some considerations to help you determine whether a post is a college record or not. So looking to see, did you use college equipment or tech when developing that post? Was this post in transaction of official business or evidence of official action? Is this a unique record that you don't have elsewhere? Or does the college have a social media record definition? But all that said, there may be some situations where social media posts are not subject to the records retention requirements, but I really do think it is safest to retain anything that relates to college business. And that's not like a routine correspondence, like say you posted on your Facebook page that there is a board meeting at 7 o'clock on Tuesday. That's routine correspondence. It is technically a governmental record, but it only needs to be kept as long as administratively valuable. So that's not a concern. But any other types of college business, I do think you're going to have to retain just to be safe. As far as First Amendment, you certainly have the right to speak just like any other citizen does, but you need to keep in mind the fact that the board is intended to act as the body corporate, and because of that, you often will have in your board operating procedures, the board president is the spokesperson for the board. So you want to make sure that since you are not, unless you're the board president, that you are not the spokesperson. So you want to make sure to clarify that the views you're posting are your personal views and not the board. So it doesn't look like you're acting or communicating on behalf of the board. If you have TASB policy, we discussed this in policy BBE. Keep in mind too that people can perceive what you're posting as official school business or official college business, even if it's personal matter, like a personal communication. And so you may run into concerns if you choose to block people who are complaining about your speech. To the extent that speech is considered government business, that can be a First Amendment violation of their free speech rights. And we're going to discuss that, and you can see that discussed more in the social media frequently asked questions documents. So a question came in about whether board members who post their opinion analysis of college data, it's not public reports, but their own analysis. That is arguably a college business because you are referring to college data and discussing your thoughts on that college data. So that is arguably college business. And so it would be a records retention concern. If your other board members see it, it could be an open meetings concern. So do keep that in mind. All right, a few other things to keep in mind when using social media is you are required to hear grievances under the Texas Constitution. And so with that in mind, you want to make sure that you are an impartial decision maker. There also may be some other provisions that require you to hear it just simply because of due process concerns or whatever it may be. But bottom line, you need to make sure you are an impartial decision maker on certain appeals and grievances. And if you're commenting on them online, it could look as though you are biased and either require that you not participate in any further proceedings on that matter, if there's like a hearing before the board, or it may, if you are the deciding vote on a particular action, such as a termination of an employee, it could result in the action being overturned. So just be very cautious when commenting about matters that are subject to grievance or appeal. It may be tempting also to basically post to all your friends a request that they comment on and help you decide how to vote on a particular matter. We do recommend against that. Certainly bringing in input from the community is very important, but making it look as though you are taking final action because you're acting based upon the vote that your friends have taken could be an OMA violation and also lead to bias. You're also creating, of course, public records when you do that. Now, what about meeting notes? Can you post your notes about an open session? Meeting, certainly that is not restricted under law, but again, it goes back to that board spokesperson concern I discussed a moment ago. It could also result in inconsistent information being published. So generally, for commentary on what happened during a meeting, like an actual notes about the meeting itself, I generally would recommend posting to the college website. But the rule is different for closed meeting notes because there are provisions that say that the college has to take a certified agenda or a recording, and those official records need to be sealed. And so arguably, closed meeting notes taken by a board member could be considered a certified agenda, analogous to the certified agenda. And so with that in mind, we recommend that you either prohibit note-taking during closed meeting or seal those notes with the official record of the closed meeting. Also releasing information because closed meetings typically happen because something is confidential. There may be another law that you are violating by releasing confidential information, or it could set you up for a defamation complaint if you're releasing information that's damaging to a person's reputation. Could have code of ethics violations. So we just really recommend against posting closed meeting notes. Okay. Closed meeting or looking to communications with the public. How do you handle those? Again, if you get communications from the public, the board acts as a body corporate. So just tell the members of the public that you can't address something on your own. You have to act with the rest of the board. We really do recommend pointing them to the administration so that they're properly following the chain of command. And that protects you from having to receive and process every single community complaint. And further, if they are complaints, they may result in a grievance that you have to hear. So it could result in the bias concern that we discussed earlier. But when handling it, don't forward it or post it so that a quorum of the board can see it. Just forward it over to the college CEO. And of course, this is a concern about records retention because you received it. They sent it to you because you were a board member. It is about a concern about the college. That is a record received in the transaction of business, and so you need to retain it appropriately in accordance with your records retention procedures, and it may then also be subject to a PIA disclosure. What about confidential records? How do you handle those? Now, keep in mind, under the Public Information Act, it is set up so that there are items that are exceptions, and then there are items that are confidential. So exceptions that the college could choose to release if they want to, or not release if they don't want to, and some that you just can't release because it's confidential by law. If you violate the PIA by releasing confidential information, that is an offense under the Public Information Act, but it could also be an offense under those laws that protect the confidentiality of the information. And once you release some information, you have to release it to everyone. So even if you're applying a PIA exception to release, once it's released under that exception, or once it's released, it is no longer subject to that exception. So you have to release it to everyone. So because this is so complicated, that's why we say just give it to the public information officer to deal with requests. Do not act independently. They'll consult the attorney. The board as a whole may have to become part of it. But don't act independently to release information. Just let the college handle that. Now, former members of the board, oftentimes I'll get questions from former members that want to look at closed session records, for example, from when they were on the board. They no longer have a right to that. Once you are no longer with the board, you no longer have a right to any of the college records. And so we do recommend that the college remind members of this and make sure to have them return any copies or any information that they may have that is college information. What about mobile device security? If you are using your cell phone or college technology for communications, you just need to make sure that you secure it just like you would be on site. Your college should have in place an information security plan that details to you how to handle password protection, etc. So follow that. Also, make sure that there are that you notify the college if there's a security breach. So for example, if you have sensitive personal data, which includes a person's name and their social security number or their health information specifically defined by law, if your phone was hacked, for example, so people could then access that personal data, and this is information that you're maintaining about the college, then you need to let your college officials know so that they can properly release to the public the security breach notifications. Now, I have received a question about a new training requirement under House Bill 3834 from this last session. You must be trained. All board members must receive training on cybersecurity. And they had originally posted that it had to happen by June 14th, but they have switched that requirement sometime in the spring, and now it's already required to have happened. So if you have not taken your appropriate cybersecurity training, there is a free DIR one online. Talk to your college administration, but you do just need to do it as soon as possible. Technically, DIR cannot penalize you if you haven't done it in time, but the legislature might come in later and do it. So just try to do it as soon as possible. Some other things to consider are make sure to be cautious about who might hear your conversations when you're on your cell phone. Don't leave your unsecured devices just sitting about. Make sure to secure them. Another question that's somewhat related to mobile devices, what if you want to use your cell phone to record an open meeting? You can record an open meeting just like anyone else, but it'll be subject to the records retention rules. But you can't record a closed meeting because, like what we discussed about those notes, it becomes considered an official recording. And so so that is a concern. And also, I get this question when, say, you're meeting with another individual and you want to record that conversation. and you're concerned about it, say it was like a member of the public that you've been having issues with, you want to record it, keep in mind that's not a wiretap concern, but it may violate the privacy of the other person. So we always recommend, if you're recording conversations, to get consent. How do you handle issues related to cyber harassment? What if someone is engaging in harassment of you online? Keep in mind that websites that allow interactivity should have terms of use policies in place that'll cover things like violence, harassment, and though they regularly change, it does allow you, if you are subject to harassment, to contact that website to ask them to take it down. If you are choosing to administer your own website, like you have an official website as the board member or something of that nature, there is some protection from other users' behavior when they use your website under the Digital Millennium Copyright Act or the Communications Decency Act, as long as you have proper policies and use procedures in place, and that anything you're removing, you're doing in good faith. As it does bring up First Amendment concerns, this is what I was alluding to earlier. If you have an official website, or if people are perceiving of your website as your board member website, then it could be considered the same as the college's website. And so if you remove items in violation of the First Amendment, it could result in a lawsuit. So make sure to post content guidelines for your website, and don't remove items simply based on their viewpoint without talking to counsel first. You may be subject to various concerns like online impersonation, things of that nature. Those are criminal matters that law enforcement can help you deal with. And finally, on the technology issues, what if one of your board members is engaging in conduct that is inappropriate online? We recommend that there be continuing education for board members on technology issues and related procedures, but if someone continues to engage in misconduct, we recommend starting with the board president or the attorney, having the college's attorney, having those people talk to the board member, then escalate it potentially to a closed session discussion. You can discuss an individual board member's conduct in closed session. There is an exception for that. Then it may escalate to a private or public reprimand, but hopefully it'll be handled earlier than that. And of course, anytime there are legal violations, make sure to report those to law enforcement. Okay, so now I'm going to pivot. That was our very high level discussion about technology. Again, we do have information in those FAQs. And of course, as Manny mentioned, you're more than welcome to contact me about technology questions. We'll have a time for questions at the end. But let's talk about just a few major COVID-19 issues, some frequently asked questions. A major concern is, what liability do you, the college, have if, say, a student gets infected due to contact with an employee, or a student dies from an infection? You have a lot of protections under law from tort liability. There is no applicable state tort claim that an individual could bring. Sometimes they may bring a federal claim under Section 1983, but that would only work if there was something called a state-created danger theory in Texas, where basically you are setting up an environment that is so dangerous that then would results in a person being harmed, state-created danger. That theory has not been recognized in Texas yet. So really, it's going to be very hard for anyone to find, unless there's some other secondary concern that implicates another law. It's going to be very, very hard for people to find you liable for illness or death. Plus, it's just hard to prove where it came from. But really, where you may run into some concerns is with employees who become sick. Employees who become sick may receive workers' comp, but it's only going to be those employees who are considered in particularly hazardous positions. But even that, it's going to be really hard to prove where they got it, and they're going to have to be able to prove that to get workers' comp. So bottom line, there are a lot of protections. So unless you have issued special contracts or agreements or something of that nature, there's a lot of protections from liability for you. We may, though, run into some concerns with, well, before I get into some of the employee issues, I will mention, we get questions about, can you require individuals to wear masks or get their temperatures taken? Issues related to temperature that's a medical concern. And so there is, the ADA is then, the Americans with Disabilities Act is implicated. The EEOC has determined that taking temperatures of employees is not an ADA concern in this current pandemic environment. So that is an exception. You can take their temperatures without violating the ADA. Same with, there's not a prohibition on doing it with students, but we do recommend that a healthcare worker do it who is given PPE and follows strict protocols. And just keep in mind, employees have to be paid for the time that they're getting their temperatures checked. Those individuals, those health workers that are doing temperature checks, it may put the person at a high enough risk they would be subject to workers' comp. But also keeping in mind, just generally with these concerns, that with masks, et cetera, you do not have to allow visitors on your campus at all. So if visitors coming on your campus don't want to wear a mask, you do not have to allow them on your campus. Students, you could choose to remove them from campus as well while they will refuse to comply. I would just recommend still giving them access to distance education so that their education is not stopped. Employees, you also can certainly require that they wear masks, et cetera, or require them to leave campus. And I'm not talking about trespass. There are some concerns under how the Governor Abbott has written his declarations, where you cannot do criminal penalties, civil or criminal penalties. Trespassing is a criminal penalty. So I'm not talking about trespassing. I'm just simply saying you can remove them and just not charge them with trespassing. But as far as employees who, for example, want to not come back to campus because they are concerned about their health, there is a lot of control that the college has, but the people are entitled to certain leave under the FFCRA, which is a federal rule that sets up 2 weeks of paid leave for employees for certain reasons. Such as they're going to get tested, they have been diagnosed with COVID, they need to take care of their children and no one else is available to take care of their child. 2 weeks of paid sick leave, but then also expanded the FMLA to allow for a reason for childcare. So if they can't take care of their children, they can get paid FMLA. There's a specific structure for how that is set up. So basically, if employees want to take advantage of this leave, they can before they take advantage of your local leave. But that said, once all the leave has been used, federal and local, if the person then chooses not to come back to work, you need to look at whether it's an ADA concern, because sometimes leave is an ADA accommodation. But other times you may find that this individual has, their leave has expired. So consistent with your absence control policy, you could choose to terminate that individual. Do have to keep in mind your contracts, if it's a contract employee, and how to handle all that. But with this in mind, this is a very stressful time. So we certainly would recommend that the college try to accommodate and find ways to work with individuals who are concerned about coming back to work. If their job is flexible and they can work off-site, that's something that the college may want to consider. So those are some of our most frequently asked questions about coronavirus and technology. I know I am at the end of my time, but certainly I can take any questions really quickly if anybody has any. Okay.
Thank you, Amy. Yes,
Sure.
and as Amy noted, we still have a couple of minutes. We're a little over in terms of time, but we are able to stick around if you have some questions. I'm going to filibuster for a minute. Quick question: is this PowerPoint available to us? We will be making the recording available. And again, as I mentioned, I will be sharing the resources that Amy has referenced throughout and showed earlier with the group. And again, those are going to be free for you all to share with your liaisons and your colleagues as you see fit. Any
Yeah.
last questions? Amy, were you about to say something?
Yeah. If there's no other questions, of course, again, as Manny had mentioned, I discussed earlier, you are free to contact us at TASB for free legal advice. That's a benefit of your membership in TASB. As long as you're contacting us on behalf of the college, it's a college-related question. So do feel free to contact us at the information that'll be provided to through Manny, but also you'll see our website information, etc. here.
All right. Well, seeing no questions and wanting to be mindful of everyone's time, thank you, Amy, again for
Certainly.
being our lead off webinar. And thank you all for joining us. We will share more information regarding future sessions coming up. Again, these will be monthly, and we look forward to engaging you all virtually and hopefully in person at some time in the future. But for the time being, thank you all for attending, and have a great rest of your week.
Thanks,
Take care.
everyone.
Bye.